Hi friends from around the world. Today is an important issue. You want to decide whether you want to advise your client to opt in. No, not to opt in, to opt out. You cannot opt in. You can opt out or withdraw your opting out, right? But before we come to that, I received some feedback on the previous videos. So I want to address some doubts which have arisen from those videos which I made before. So let's talk about a fee. Is it necessary to pay a fee for opting out? No, there is no fee for opting out. You can do it with the registry, and there has nothing to be paid for. Second question, is it possible once you opt out to withdraw its opting out? Yes, it is possible, but you cannot do it constantly. You cannot do it today I opt out and tomorrow I withdraw and the day after I will opt out again. This is not possible. You can do it once, meaning that you can do the opting out and at a certain moment withdraw the opting out, but you can't do it indefinitely, which is clear. Now, what is the fate of the supplementary protection certificate? So this one which extends your patent beyond the 20 years limit. Well, it is the same for the patent, so there is nothing special with SPC. Once you decide on the patent in one way or the other, the SPC will go the same way. Now, what is is it possible, so to say, to make an opposition procedure and to proceed with litigation within the UPC system? Yes, it is. So, for example, if you have a damage claim in the UPC system, you can't do it at an administrative one in the EPO, but you have a revocation opposition claim and you can do it within the EPO system. So you have a bifurcated action, so to say, one in the UPC and the other in the EPO, although that one of the EPO, they may end up as well in the UPC, right? But in principle, it is, so to say, it could be cheaper, so to say, to do it in an administrative way, in order to think, well, probably it will leave that administrative way, it will not go up to the UPC. So it is possible to do one thing in the UPC and another in the EPO system. So it is not, so to say, excluded one from the other, right? Now, what about contractual disputes? Contractual disputes like, I don't know, something about a license or something about a contract to sell a license to another and you want to enforce that contract. Well, these are private, so to say, private issues which are around a contract. And this has to be done in national court. So this is not which is being done in the UPC system. UPC system is for, injunctions, damages, for information on the patent, of the sale, infringement, these kind of things. We talked about this. So contractual things with a contract you have made, with a license you have done with a licensee. So this is being done in the national courts, right? Now, what is the situation if you have a claimant who has, so to say, opted out, and you have a defendant who has not opted out? That would be the defendant is within the UPC system, whereas the claimant with its patent is outside the UPC system, so would be, so to say, be sued in national courts. Well, it is just as with trademarks and with general considerations. The patent in dispute is the defendant's patent. So if you have a revocation claim of the defendant's patent, it is about the defendant's patent. It's not about the patent of the claimant. Meaning that if the claimant's patent is in the UPC system or not, and the inverse situation is for the defendant's patent, it's about the defendant's patent. It is not about the claimant's patent. So if the defendant patent has opted out, well, that is on national courts. If the defendant's patent has not done anything, it is within the UPC system, and you as a claimant, you are, so to say, condemned to pursue your claim within the UPC system. Is that clear? So that is an important issue about what is your situation, and is that relevant, and what is the situation of the defendant, and this is the relevant one if you are the claimant, right? So that is an important one. Another issue is with regard to a question with regard to the judges. So what is the qualification of the judges, and what will be their future take on these? Will they be rather inclined to one system and to another system, perhaps a national system? Will there be, if it is a German judge, will be inclined to make, so to say, a German decision? Well, the UPC and also the regional courts, they have to apply the UPC system, right? If it is a UPC litigation. Now, the UPC system is in the agreement, in UPC agreement, and the unitary patent agreement, and they have to apply those. So that may be somehow different with regard to the national legislation. Moreover, the judges are composed on an international level, so they come from different contracting member states. So you may have a panel of 3 or panel of 5, depending on what it is, and they come from different countries. So their input into the system is somehow different. They are not limited to their own knowledge or to their own experience. They will discuss it from a different national angle. Such as with regard to the trademark, so the Court of First Instance and the European Court of Justice, they started to make trademark cases when? Around 1997, 1998 or so. And they started to make case law on a new system. So what will be that system? Well, there is a prediction of whatever kind, but the experience is they came up, so to say, with a new case law, on a genuine case law on European trademark law. And this over time, so after 20-something years of case law, that is a corpus which is consolidated, which we know beforehand how the court sees these things. And they see it in a way which is somehow genuine to European trademark, but it is, so to say, if you regard all the EU member states and their takes on trademarks, it is somehow in the middle. It is not to the extremes. It is, if you take into account all of them, all of the case law of the member states, it is somehow in the middle. And I don't think we will hear some different experience. So this is what I wanted to tell you with regard to some questions. Now let's come to the considerations. What are the considerations? What are your strategic advice to your client when they ask you, or when the question comes up, what happens with the UPC? And my strategic advice is that you have to... No. It doesn't go like this. There is no one fit for all advice, right? You lawyers, you know that it depends, right? It depends on the situation. It depends on whatever patents you have. It depends on the cost. It depends on your strategy, business strategy. It depends on well, let's go through some of these things in order to get some more feeling on how your advice could play out. Let's starting about the cost. You have the cost of the UPC system, which is, well, we discussed about it, and you have the cost of national systems. National systems, we know that can be between 17 and 22 contracting member states with the UPC. Now, if you well, let's make a case. You have to look at the competition, right? The competition of your of the business of your client. Now, the competition. Let's make the competition is composed of SMEs. So, what happens with the SMEs? The SMEs are, so to say, afraid of litigation. Now, when it comes to possibility to go to the UPC, well, they may be deterrent of cost. Well, that would be one consideration. But the consideration which is here is, what will the competition do? Will they sue you, or will be you the one who is active with regard to the litigation? Now again, if it is you doing the litigation, well, it is not up to you to make a decision about UPC or not. It is about the defendant's patent, right? If you want to make an injunction against the defendant's patent, you may want to, you may do that if the defendant patent has been opting out in the national court, if not in the UPC system. That is what it is. So it is only in order to make clear when you are in the defendant's place, then it makes you have, so to say, the initiative. You have the possibility to either make the claimant go to the UPC system or make the claimant go to the national system. That is what I want to do. Now, if that means if you in the past, your client in the past has been on the claimant side, there is not much about opting out. It is about the competition. So you have to look at the competition and the past history of competition, whether you have to go to one and the other, or you want to go to one and the other. Well, it is not about where you want to go, because you have no final word on it. So that is, well, you may have a final word of it. For example, if you are suing with a European UPC patent, so to say, with a UPC patent, you are suing a opted out patent, and it makes a counterclaim. So the defendant makes a counterclaim against yours that your patent is not valid. Well, then it goes to the UPC. Then, yes, there's involved a European patent within the UPC system, and then it is the UPC. So look at your your competition, look at your own history, the history of your client. Is it active or is it rather passive? Is it the one who is sued all the time by the competition? And then if it is the case, it is sued by the competition, then it is impacting on the future litigation, whether you will opt in and opt out. And if, for example, it is a SME, you may not want to opt out, because this will come into play and maybe have a deterrent effect against the SME. Perhaps you want to be sued, you're happy to be sued. If you want to provoke litigation in order to, I don't know, to destroy your competition because you feel strong, and if you win, you get the cost so reimbursed, so the fees, etc. So that is about strategic consideration, right? It is that all comes into the cost consideration. Now, if you feel confident, for example, if you feel confident that you have a very good, a very strong patent, and you feel confident, then you may want to opt in, so to not to do anything and being within the UPC system, because if somebody want to challenge you, you go to the UPC system and you know you will win. Clear case. You will not have to go to different national systems and have in each system one law team to defend your client. If you have one system and you can manage it well, and you get reimbursed, so that would be a strong case. Now, the other way around. You have not a strong patent and European patent, and you may, in Germany, it may be if there's a central attack in the UPC system, right? One central attack, you are dead. If the central attack is successful, you are dead. That is the consequence of a unitary title, right? So if it is opted out, so you are with the bundle of your national patents, which is litigated in the member states, then what would be the possibility? Well, the possibility would be that you are cancelled in Germany, but you are still in France, right? So you get a revocation in France as well, and it is successful. So, you have still others. But it is deterrent for your competition to go after you one after the other in order to destroy your patents. It comes me to another question. Is it possible to opt out for European patent in France but not in Germany? No, that is not possible. If it is the same patent and the same claim, you opt out for everything. You cannot single out some countries for this, and for this I'm opting in. That is not possible. Okay, so preliminary ruling, that is another consideration you want to look at. You have preliminary rulings within the UPC system, and this preliminary ruling can be enforced in 17 or 22 member states, whatever contracting member states we will end up at the end. So one possibility, and you get a enforcement in all of them. But this is only, if you're the claimant, and the other, that is rather about the other, what happened with the opting in or opting out. Now, what is about a portfolio? You have a portfolio of patents. One is stronger and one is less stronger, and you have divisional patents. Well, you may decide to mitigate the risk, to make the stronger ones into opting, let it go in the UPC system, and the other you can opt out. So you can have the possibility of a central system and central, one unitary, more effective, so to say, rather than individual litigation. But you want to be sure against, a central attack, or you want to be left with something, you want the whatever. You see my point, right? So these are considerations which have to be taken into account. Now, wait and see. That would be another possibility. What is it about wait and see in the future? I said you can opt out and you can withdraw your opting out in the future, unless there is already something pending in the one or the other system. Then you're bound. You cannot do anything else, right? So what you can still opt and see and take this risk, wait and see, and how the system evolves. And if you get confident at a certain moment that the system works, that the case law is sound, that they know what they're ruling about, they have the expertise. So on the judges as well, there are some technical guys inside as well. That is not only about law, there are technical expertise as well. This is a mixture of law and technical expertise, what the judges have. So you may opt to wait and see and make your final decision afterwards in the light of what will be the judgment, the case law we will see, right? So that is what I want to tell you. There's no one-fit-all strategy. No, it is about considerations. It's about discussion, the history of your client, what will be the prediction for the future, which is hopefully based, or more or less based on the history, right? It will not completely new, but it depends also on your client, on the portfolio, on the strength of the patents, on cost considerations. What will the competition do? So these are things you should discuss with your client in order to come to a conclusion. So, sounds right to you? Please give me your comments.